And we're back. Another session. I have a wonderful topic today, and it's why get estate planning in general. Like everyone says, yes, you should do this. No, you should, oh, do you have a will? Do you have a trust? But really, why?
I love this because I think about this all the time, and I always why? Like, who cares? I'll be dead. Why?
Exactly.
Why do I care? But then you actually think about it, and honestly, if you don't have anyone you care about, right, would be very sad, and I hope that is no one. I hope that is no one. But if you have no one you care about, it doesn't matter. It doesn't matter because sure, the state's gonna decide who gets your stuff, and
they have to go.
You're gonna have to go through probate, and your estate's gonna have to pay for this, and it's gonna be really long, and it's gonna be really traumatic for whoever has to do it, if anyone does it.
Right.
But you'll be dead, so who cares, right? And so
100%.
That's true. There is definitely something to that statement, but I presume in most people's lives, and I hope in most people's lives, you have lots of people that care about you that you care about.
Right.
And I think that when the question is asked, why would I even do this? The answer, even if it's not monetary based, even if you don't care about paying taxes, you don't care about paying attorneys, you don't care about the probate process, you don't care about paying, you don't care about the money aspect of it, you have to think about the emotional turmoil that everyone has to go through to deal with this.
Right.
And I say this all the time. When someone you love passes away, you want them to be able to focus on grieving your passing. You don't want them to have to focus on everything else.
Yes. Because it's a lot.
It's so much.
It's a lot.
It's so much. It's so much for anyone.
Right.
I don't care how proficient. I don't care how intelligent. I don't even care if you're an attorney.
If you're expecting it, if you're not expecting it.
None of it matters. It is still emotional.
Right.
All of it is. And to have to go to our office, having to sign documents, having to locate all of this stuff. I mean, the byproduct of a person passing is that you have to close up all of this stuff.
Right.
So you are already left with this grief, and now you have all these other things that you have to do.
Right.
You don't want to have to deal with me in the interim.
Right.
Right.
And when you say you, it's the probate process. And people hear probate, and maybe they do, maybe they don't. But what is probate?
So probate is the court process by which the court will allocate your assets and debts and your beneficiaries of who actually will inherit your estate.
And how do they figure out who is going to inherit your estate? It's by statute.
Well, if you have a will, it will go pursuant to your will. But if you don't, it's called passing away intestate. With a will would be testate. If you pass away intestate, there's a succession statute that says if you pass away, it goes to X, Y, and Z. And there are provisions governing separate property, community property. There are exemptions for certain things if you fall under certain categories. So it's not just super cut and dry, but it is black and white. You will fall under these provisions if you don't have a will. And why do we always say that's problematic? Why is having your property go by statute potentially problematic?
Because it doesn't go where you want it to. And even if it does go to who you want it to, maybe it doesn't go at the timing you would have preferred them get it.
Like what?
Say if you have young children and they would be who would inherit if something happens to you. So now you have a young child that all of a sudden inherits a bunch of wealth with really no instruction on what to do with it or how to do with it. Maybe they're not mature enough to handle it. Maybe they have addiction issues. Maybe they have special needs. And by getting the inheritance from you, all of a sudden now they're disqualified from all their benefits.
Yes, there are many different ways that your estate going by statute could be problematic. And you've named a lot of them.
Right.
And at the same time, could you imagine so most houses, at least in Nevada, we're in the 400 and 500 ranges easily.
Yes.
All right. If you're a house, you're somewhere in the 400 and 500 range.
Right.
Maybe. Right. You're probably not much lower than that at this moment, at least.
Right.
Could you imagine as an 18-year-old inheriting $400,000? Could you imagine that? I think I'm a responsible person. Right. I think I was responsible at 18. I would not have been responsible with $400,000 handed to me.
Right. I wouldn't have been responsible with all of it. I guarantee that.
Exactly.
Or my friends wouldn't have been responsible on my behalf.
Right. Exactly.
Right.
And I think I was a very good child growing up
Right.
With a good head on my shoulders, I knew about finances, but even then, I would have
Not been prepared.
not been prepared and not been responsible as I should have, and would probably have nothing left by the time I was 25.
Right.
Now, if you had put it in a trust and, sprinkled the distributions to me or made me do certain things before I could obtain those distributions.
Right.
Now
had some oversight over it. Like even though I'm not giving you an outright distribution through the trust until a certain age, I can still provide for you.
I'll take care of you.
I can still the trust can still take care of you. It can provide, your health, your education, maintenance, support. It can provide for all those things, but it's not giving you the outright distribution so you can go have the biggest party of the year.
Right.
Which is, I think, an important distinction. It's not like you get nothing. You're on ramen noodles until you're 25, but then all of a sudden you get this
huge inheritance. Yeah.
Right.
No, it can be drafted so that you're still taken care of. But if we circle back to that probate process, why is it so bad? So first we talked about the emotional turmoil that your family has to go through.
Right.
The second part you've also already touched is we could have distributions go to the people we want, but not necessarily by the method in which we would choose. The next is going to be the potential for conflict. All right. So leaving no direction is terrible.
Right.
Because, and we'll get this one a lot, I took care of mom and dad. I was with them.
Right.
I paid for their X, Y, and Z. I stayed with them. I quit my job to take care of them. All of these things.
Yep.
And I want compensated for that.
I believe I should be compensated for
Exactly.
that. Yes.
And right or wrong, I'm
sure.
not saying it's right or wrong in any capacity to desire that, but that is always a huge problem.
Right.
Somebody always thinks that they deserve more. And the issue becomes, if you don't have documents, you're through the probate process. You're there.
Yeah. And the court is going to decide, and they're not going to say, oh, yeah, you get a little bit extra because you gave up your career to take care of mom the last 5 years.
Right. Was there a contract? I mean, they're going to go into all these questions that you probably just did it because you're a good person and you were closest, right?
100%.
That's usually what happens.
And maybe didn't have even a conversation about what the compensation, just figured it was taken care of.
Or you didn't apply to get that compensation previously. Right. And so as a sibling, you have one that took care of mom and dad and wants to be compensated or believes they should be because that's fair.
Right.
And then you have the other side that said, well, mom and dad paid for you to have a place to live. They paid for your groceries. They paid for, are you going to pay that back? And so you have these competing mentalities that could have been avoided if you weren't in that probate process because it was already set forth. Like mom and dad already thought about that.
Right.
And so that gets another part of probate that's really yucky is that conflicts that could have been avoided kind of rise to that surface because they weren't addressed prior.
Sure. And then the other thing to think about is if you have minor children and you're through this process and you can point out who you would want to take care of your children if you and your spouse or their other parent pass away. And you can say, this is who I'd want to raise my children. And you can't do that. You do that in the will. But if you do not have a will, then there's no guidance as to who your desire was to continue to raise your children.
Exactly. And a lot of people think that, a will is important because of the guardianship aspect. And I agree. I mean,
for sure.
That's one of the key. With minor kids, a will, absent everything else of who it's going to, that guardianship piece is huge.
Right.
And that's a lot of what young families think about often is if we pass, and it always happens at vacations. They're going off for their first vacation together.
Without the children.
Yes, without the
right.
Good for you. And it always comes, who's going to take care of them? Under what circumstances? What's it going to look like? All of these things.
My family, his family.
Exactly.
Who's going to raise the kids? Who's going to be the...
And if you don't have that in a will, then it's going to just be a fight of who the court decides for you. And you don't want that.
No.
Because maybe you hate your in-laws or maybe you love your in-laws.
Yes.
Maybe they do or they don't get guardianship. And at the same time, if I don't mean to put down form-filling websites because I think they have a purpose.
100%.
But another problem that you find with those is if you are doing a will and you are naming a guardian. So I do a will, I name a guardian. I'm going through the probate process now. And I really, really loved my brother-in-law. I love my sister and my brother-in-law, and I think they make great parents.
Yeah.
They got a divorce.
Mm-hmm.
Okay? So now my brother-in-law is no longer involved. Now my sister's dating somebody I don't like.
Right.
And I never changed it. And I never specified that I only wanted her to be guardian if she was still married to X. And so now my kids are potentially going to my sister, who's now in a position where she isn't going to be the great guardian because I believe that them together was better than her alone.
Team. Yeah.
And so the form filler didn't
work.
ask that question, didn't talk about that. And so now we're left with a situation that we wouldn't have necessarily wanted. And again, to kind of echo back to my very first point of who cares, you could just not care.
Right. But you do.
But
They're
you
your
do.
kids.
Right. But you do.
I was like, oh, but you do.
You could not care.
Right.
But you do.
But you do. Similar, exactly what you said. Yeah, I want my brother and his wife to raise the kids. But if my brother's a single man, I don't necessarily want him raising my daughters. It's just the situation. Or if they don't have custody of their children, am I going to give them custody of my children?
Exactly.
Part of it, why I thought it would be great, is because they would be raised with other children. Well, if they don't have custody of them, maybe that isn't what I want.
You lost the benefit of what you originally thought.
Right.
Yeah.
So,
yeah, there are a lot of things. And if we kind of circle back to that probate process, again, we have that emotional toll. We have the potential for conflict. We have it not going pursuant to the people you actually wanted to going to. Alternatively, it's going to those people, but not in the same terms. And lastly, the cost of just going through probate. I mean, if you're going super, super cheap, you're around $3,000.
Yeah.
And that is not likely.
Right.
More often you get into the 9, 10, 11,000, 12,000, 13,000, and potentially much, much higher.
Especially if you have that house, like we talked about before. The average price of a home in Nevada, if you're just going through probate with that house, you're right around $8,000-9,000.
Well, yeah, and it's by statute. So you could actually go look up what it would cost to go through probate with the value of the assets that are going through probate. Right. Again, it's by statute.
Yeah.
Attorneys can charge hourly, and we charge hourly for some. We charge by statute for others. But you can actually look it up, and you can say, okay, if this went through probate, I would be paying statutory attorney fees X. And then you have the person that's taking it through probate that can also have fees. The personal representative can also take fees in an administration.
100%.
So now you lost fees to the court, you lost fees to the attorney, you lost fees to the administrator, potentially all of those. Yeah. And you've lost a ton of time.
Time. That's what I was just going to say. And time.
Time.
What is the average time to go through probate here in Nevada?
So if you're solely statutory, you have about a month to get a hearing.
Yep.
And this is if everything is order, you got everything, but you probably didn't.
Right.
So there's probably, let me just talk realistically.
Yeah.
You probably have a month to get the death certificate. Yep. You probably have a month to gather assets and debts. Mm-hmm. You have a month for the hearing to open probate. You have, if it's, under 300,000, 2 months for creditors.
Okay.
So right now we're already at 4 months?
Yes.
And then you probably, if everything is ready to go, then you probably have another month for a hearing. So 6-ish months.
How many?
On the short end.
Yeah, I was going to say, how many probates have we taken through that are under or at 6 months?
1, 2, maybe.
Right.
No, and I'm giving you almost best case scenario.
Right.
Now there are different types of probates. You could just not probate it. You could do something called a set aside, which is limited to the number of the value of the assets. Again, that's not actually an administration, not technically probate, but you are in probate court. But again, that's based on the value. So again, if you have a house without a trust, you're probably at bare minimum in that 60-day wait period for creditors.
Right. Now, we've talked about before different ways to avoid this probate, this dreaded probate that we've talked about. One we've talked about quite extensively is a trust, but there's other ways that you can avoid probate.
Right.
You could put beneficiaries on all your accounts. There's ways to do that even for your home. There's transfer on death deeds. You can put everything as joint tenants. So that means when the first person passes away, everything, that house or whatever's labeled as joint tenants, goes to the survivor. However, when the survivor passes, then we're going through probate on their side. So it only works for the first passing.
Yes, it only works for the first person passing.
If you go together, we're in probate. So it's not 100% foolproof, but for the first one, it is.
Yes. And you really have to be careful about taking title as a married. I mean, we've seen this a lot.
At least once a week.
Yes. We have to be very careful because title companies, and no offense to them,
Right.
they're not attorneys. They don't really understand taking title. They know,
Or realtors. They're
Right.
not attorneys.
They're not
and
attorneys.
They just say, oh, it doesn't matter.
Right. And it does.
It
It
does.
matters because there are only two ways to hold title. What are the two ways to hold title?
You either hold it as joint tenants with right or survivorship, which means if one of you passes, the other person gets it full. Or tenants in common, which means you can say how much you own of this house and how much you own of this house. And then you can sell your interest, or when you pass away, your interest go according to your will or your trust documents or your the probate, if you have to probate it, and the other person gets their percentage of it.
Okay, so if I pulled the deed on my house and it says my husband's name and my name as community property, how did they do that if it's not joint tenants or tenants common?
So that's an error that has been made many times. And the default is it's tenants in common. You own the property 50-50, or if there's no percentage listed, you own the property 50-50. And that means if one of you passes away, your 50% gets probated or goes according to however you have your estate plan.
Your 25%.
Right.
Right. So people often come to us and say, but it said community property. It said as husband and wife. Why don't I get it?
Right.
And the answer is because you don't own it as joint tenants.
Right.
You own it as tenants in common. So while you own 50%, the statute is going to say 25% of that is automatically yours. That other 25% is going to go probate.
Yeah.
Which you ultimately will end up with it.
But more important than not even being able to, you can't sell the house.
No, you're stuck.
You can't do
You can sell
anything.
50% of the house.
Right.
But how many people want to buy 50% of a house?
Exactly. I mean, you can't. So if you can't pay the mortgage by yourself, you are stuck. You can't sell it because you have to get court approval to sell it. And if you can't continue to make the mortgage payments because your spouse was the breadwinner or whatever the situation may be, you're really in a bad position.
Yeah. So let this be a lesson to go look at your deed and see what it says.
And look at your deed, and if it does not specifically say joint tenants, and that's what you're hoping for, you should come see us.
Or with rights of survivorship.
Or with rights or
Right.
rights.
Because you cannot have community property with rights of survivorship, and that would still be okay. But there are certain terms that need to be included.
Yes.
Yeah.
Just listing it as community property is not enough.